Hello everyone. Today we will explore the sources of international law which include main sources, subsidiary sources, the new or possible sources. My name is Farisha Alia and I will be presenting the main sources which include treaties, international custom and general principles of law. We now will discuss subsidiary sources which include judicial decisions and legal scholars' teaching. Finally, Wani will introduce the new or possible sources like resolutions of international organizations, principles of equity, and unilateral acts. The International Court of Justice is guided by Article 38 of its statutes, whereby it utilizes a diverse range of legal sources to interpret and shape international law. These sources including treaties, customary international law, and general principles of law. Treaties, as formal agreements between sovereign states or international organizations, plays a fundamental role in regulating various aspects of international relations. Importantly, once it is being ratified, it became a legal obligation. For example, United Nations Charter or the Geneva Conventions, it underscored their significance in shaping global norms. Customary international law emerging from consistent state practice and opinion juries, it binds all states regardless of their treaty participation. Furthermore, it covers diverse matters from diplomatic immunity to state responsibility. Customary law reflects shared norms within the international community. However, the principle of persistence objective allows states to reject customary norms provided that there is a clear evidence of objection is presented. General principle of law is recognized by the international tribunals due to its roots in justice and equity. It offers guidance where the treaty and international customary law are silenced. These principles, such as good faith and non-discrimination, contribute to the resolutions of legal disputations in a global scale.
There are two types of subsidiary sources, which are judicial decisions and the teachings of the most highly qualified publicists. So, firstly is judicial decision, including those of the ICJ. It serves as pivotal instruments in the interpretation and development of international law. While binding only on parties involved, these decisions establish precedents and clarify legal principles. Also, it fostering consistency and coherence in legal practice. For example, the Art of Congo and Belgium 2002, the arrest warrant of 11 April 2000. The parties relied heavily on the decision of the UK House of Lords in Pinochet case, R and Wall Street Metropolitan Stipendiary ex parte Pinochet Urgati 1999. The next of subsidiary sources is the teachings of the most highly qualified publicists, it known as the writings of legal scholars that offer valuable insights and interpretations. Its contributions shape the discourse on international legal issues, that influencing the evolutions of legal norms and guiding practitioners and policymakers. For example, writings of esteemed publicists that had an increased publicist in the PCIJ era. Today, courts and tribunals rely less on international legal doctrine, but nevertheless, opinions and resolutions of collective bodies of international juries such as the ILC or the Institut de Droit International still relevant.
There are three types of new or possible sources. The first one is a resolution of UNGA, and the second one is an unilateral act, and lastly is the principle of the equity. The first sources is the resolution of United Nations General Assembly. Many resolutions of United Nations General Assembly are material sources of law. It is it's disputable whether tantamount to independent sources of law. Based on decided cases, resolution by United Nations General Assembly only declaratory of customary law or evidence of opinion juries. Resolution, recommendation, and recognition of the United Nations General Assembly are often resorted to not only their persuasive value on international duties and obligation, but also as evidence of political consensus on various international relation disputes. The resolution may also have a very significant influence on the subsequent development on international law and practice. It can be seen in the case of Nicaragua. The ICJ relied solely on GA resolution when establishing the customary rule prohibiting the use of force and rule that necessary opinion juries can be deduced from the attitude of the state to the relevant resolution. Also, based on the legality of the threat and use of nuclear weapon case, the court stated that even if the resolution are not binding, they may sometimes have normative value. They can provide evidence for emergence of opinion juries. Furthermore, the second sources of international law and the new or possible sources is an unilateral act, where it have a distinct legal value. Acts are unilateral, although they are performed by a single state acting under its own volition. The consequences of the conduct are governed by the international law. Other than that, a unilateral act or state may be defined as an expression of will emanating from one state or state, which produces legal effect in conformity with international law. For an example, it can be seen in the nuclear test case where the court held that the France had assumed legally binding obligation through unilateral declaration made to the world at large to the effect that it will not hold any further atmospheric nuclear tests in the Pacific. Other than that, equity is also a legal principle that is exercised commonly by the court in deciding a case. Article 38 para 1C of the ICJ statute state that the court may invoke the legal principle accepted in all or most of the national legal system. Further, it is stated that the court may decide a case ex aequo et bono, which means that the judge will consider what to be just and equitable in deciding the case. It is important for the international courts to use it in the absence of treaty and customary international law. Other than that, he also stated that the principles of equity are allowed by the authority of Article 38 para 1C of the statute, since the principles are common to all national legal systems. One of the equitable principles in the international law is natural justice, such as the doctrine of good faith and estoppel. It can be found in the case involving the delimitation of maritime boundaries like Gulf of Maine case and North Sea continental shelf case. The court stated that the concept of acquiescence and estoppel follow from the fundamental principle of good faith, even though that they are not expressly mentioned in international law. It shows of equity in delimiting the boundaries between the states. Besides, the duty to provide reparation in consequence of a wrongful act, legal logic, and equitable principle in procedural law are among the examples of the general principle in the international law. The principles of equity may be considered as the general principle of law mentioned under Article 38 para 1C. In addition, the principles are applied in most of the national legal system. To conclude, the court may apply equitable principles as a primary sources of international law after the international convention and custom.
To conclude, ICJ relies on a multifaceted approach to international law, drawing tapestry of legal sources to ensure the effective administration of justice and the advancements of global cooperation and peace. So that's all for us. Thank you.